I'm going to put chapter 15 and chapter 16 on the same video to kind of save some time, and they both kind of go hand in hand. But in chapter 15 or paragraph 15, page 167, that is the default paragraph. And again, this contract is a contract, which means there are items and issues that have been pre-agreed to at the time the parties signed and agreed to the contract. And default is kind of one of more of the negative things that happens in real estate. And the book goes into good resolutions to kind of a bad situation, and then a bad resolution to a bad situation. One of the key factors to learn in this class is the correct way to dispose of a contract when it goes into default. And default just means that one of the parties has not complied to the basic general terms of the contract. And typically, you see more buyer defaults than seller defaults. Typically, sellers, when they sign that listing agreement and they put that sign in the yard and they're ready to sell. And of course, there are a lot of hurdles to overcome for a buyer before the default provision kicks in. So the buyer has to get out of their option period. Number one, they have to basically satisfy their lender requirements, and they have to have their loan approved. So before they can face any consequences of default. Basically, default is when everything is ready to go, the appraisal is in, everything is finalized, you're just waiting on closing, the agent. And basically the buyer just doesn't want to close. They just, for whatever reason, they show mom and dad the house, and mom and dad don't like the house, or they don't like where it's at. They change their mind. They think they're getting into maybe over their head or getting in too deep financially. So typically, the agent working with the buyer is you're going to be the first one that hears about the default, because the buyer makes a phone call to the agent and says, look, we have changed our mind, we don't want to close, what do we need to do? And there's a couple of resolutions to this. What I would highly recommend that you do is, at the moment you find out about this default, is you notify your broker. I mean, there's nothing in the rules that says you have to do this, but until you have some deals under your belt and you kind of understand where all this is going, you need to let the broker of the firm know what's going on. And sometimes the broker can get the buyer into the office and just sit down with them and say, look, what's going on? What are your reasons behind this? And sometimes, the buyer just says, well, I don't feel comfortable with the way the seller did the repairs, or I'm having difficulty understanding my truth in lending statement from the lender. So there's just a lot of issues that sometimes the broker can kind of put into perspective for the buyer or whoever the defaulting party is, and typically it's the buyer. But sometimes the broker can kind of put that into perspective and salvage the deal, where it will go ahead and close. Other times, that's just not a possibility, and it just, for whatever reason, is just not going to close. And now we got to figure out what to do. Typically, and you can, if you want to read on into paragraph 18, which talks about the duties and the role of the escrow agent, which is the title company. The parties have to make a written demand for the earnest money. So a written demand for the earnest money is a termination of contract and release of earnest money. And those forms are both in the book, and it directs a title company on what to do with the earnest money. So in the event of a buyer default, typically the seller is going to make a written demand for the earnest money through their listing agent. So the listing agent is going to prepare the earnest money release. They're going to have the seller sign it. They're going to send that to the title company, and that will serve as the seller's demand for the buyer's earnest money. So the buyers are basically suffering a penalty for their default in the contract. They're going to lose their earnest money. However, the buyer has to agree to that. The buyer has to basically say, look, we agree we're in default. We agree to the terms of the contract. We understand that. So we are going to sign this release. We're going to give our earnest money to the seller as a penalty, as basically our penalty for defaulting in the deal. Okay? Well, in that situation, you have a peaceful resolution to kind of a crummy deal. The deal's gone bad, but everybody understands, everybody's on the same page. The seller's going to put the house back on the market. The buyer is going to go look for something else or move into an apartment or a rental or whatever. So that's a peaceful resolution. The other resolution to that is where you cannot get a buyer or the seller or both to sign the earnest money release. And those are the situations where those are just kind of turned into nasty deals. They're just not good deals. You have to be real careful as an agent not to be perceived as giving anybody legal advice. We're not attorneys. We're not trained in that. We don't have a law license. So in the event you have a buyer or a seller that fail to acknowledge that there's a problem by signing the release and disposing of this contract, getting the earnest money to the appropriate party, you have a problem here. As a real estate agent, the only thing we can do is get them the forms. We cannot make them sign these forms. We can have them refer to certain paragraphs in the contract. Please read this. Let's really think about this. But we can't make them, at the end of the day, we can't make them sign anything. So they have to understand what their liability is if they don't. And paragraph 18 was changed a few years ago because there was millions of dollars of earnest money in title company trust accounts that were just not dealt with, just sitting there. So there was a provision in paragraph 18 that just says that either party failing to sign the earnest money release can be liable up to 3 times the amount of the earnest money deposit. So you have, your buyer and seller, have to understand that, if there's $1,000 up in earnest money and they're just being hard-headed and they don't want to sign the release, then they can be liable up to $3,000 plus their earnest money. So, a lot of times when people realize that and they understand that, they could suffer a significant penalty for not signing that, they go ahead and sign it and move on down the road. The other alternative for both parties in the event of a default is a lawsuit for specific performance. Nobody wants to get involved in one of these. They're costly. Basically, in Texas, it's highly unlikely for an attorney to take a case for a buyer to sue a seller to sell their homestead. Homesteads come under different under different laws. They're treated differently. But on the flip side of that, if you have a seller that has maybe gone through some expense, maybe hired a mover, maybe already moved out, suffered some actual money loss as a result of this buyer not buying, then the seller, I have seen this happen where the seller finds an attorney that will take the case, and they basically send the buyer a letter of demand or written demand letter trying to force them into buying the property. And you have to understand, these are contractual agreements. You know, the buyer, when the buyer signed this, the buyer agreed, in essence, to suffer consequences in the event of a default. So they're kind of rough deals to get through. The broker needs to be intimately involved in these kind of situations, because it's real easy to fall into the trap of giving legal advice to your buyer, or in some instances to your seller, and we just don't want to. We don't want to get into that. That's not our field. So you have to make sure that the broker understands, or your sales manager understands where this deal is, and can guide you through the right process to handle this correctly. So anyway, Chapter 15 is kind of one of the more the negative aspects of the real estate industry. It doesn't happen all that much, but it does happen periodically. Y'all can go ahead and read through the chapter. And moving on to Chapter 16, dispute resolution. And in your book, there is a couple of different check boxes. Well, in the new contracts, it doesn't give us the option anymore to mediate. It encourages mediation. So there is a slight change there from the book to the new contracts that you have in your course assignments, in your contract exercises. So mediation is a real important part of really any, there's mediation in divorces. There's mediation that occurs or can occur in civil lawsuits. Mediation is a great avenue to keep situations out of a courtroom type scenario, which it basically costs everybody a lot of money, a lot of time. If you can get a professional mediator to try to help resolve a dispute between your buyer and seller, it is highly advised. And even the new contracts really don't even give us a choice. Well, I had a situation that occurred in my company a few years ago where a buyer and seller had a huge disagreement about a driveway. It was a real expensive house. The driveway was suitable at the time the buyer looked at the house, and we had one of these big rains, and it washed a bunch of the gravel out, and all of a sudden it had holes in the driveway, and it was just really rough and difficult to get to the house. So the buyer said, look, I'm not closing until this driveway is fixed. So we had to mediate the deal out. There was a driveway allowance reinitiated into the original contract, and the deal closed. But there was a mediator that helped the buyer and seller come to a peaceful resolution in the deal, and the buyer was happy, seller was happy, and it closed, and the agents got paid, and everything was good. So mediation is a great deal. You can read through the rules on mediation in Chapter 16, and then Chapter 17. I'm going to go ahead and throw that in too. It won't take very long. Basically deals with attorney's fees in the event of a lawsuit between your buyer and seller. And basically, Chapter 17 says the loser pays. So the prevailing party in a lawsuit gets their attorney's fees paid by the non-prevailing party or the loser. This is on contractual issues only. The most real estate lawsuits are brought under the Texas DTPA, or the Texas Deceptive Trade Practices Act. That's where most lawsuits are brought under, which has different rules on attorney's fees. One good thing about this language in our contracts is that it prevents some frivolous lawsuits. So, you have a buyer or a seller that are, suit happy. When they take these contractual issues to an attorney, the attorney, of course, reads this paragraph in the contract and says, well, we've got to have a pretty good case, or we're going to have to pay their attorney's fees in the event we lose. So attorneys do take more time in reviewing these type cases to make sure they are legitimate before they take them, and that's a positive thing for this language. So that all rolled up into one, 15, 16, and 17. Hope this helps. Thanks.